get started. And so as you can see on the screen, we're talking about settling original creditor lawsuits. So we mean places like Capital One, Discover, Synchrony Bank, Community Bank, Barclays. I mean, just all these original creditors. In other words, not debt buyers. So we're not talking about LVNV, Midland, Portfolio, Calvary, Jefferson Capital. We're excluding those. So what do we do when we're sued? And what I'd like to focus on in this is really 5 mistakes that I see people make. And this is from both defending people who have been sued by original creditors for, I don't know, 15 or 20 years, but also seeing a lot of people come to me after they've handled their own case, or maybe another lawyer has handled their case, and just seeing some mistakes that have been made. So I hope this will be helpful to you. As we always do in these, if you have any questions, just type them in. I'll try to keep an eye on the chat feature here and stop when I can to definitely answer any questions possible. And then we'll have at the end, I think, some time for just some open Q&A, whether it's related to this or not. I'll be glad to answer any way that I can. Okay, so let's just look here at these mistakes. The first one is the biggest one, which is you're sued and you do nothing. And we'll particularly talk about this when we get to that slide. I see this happen where you get sued, you're served with the lawsuit, you're talking to the collection attorney, and you're going back and forth. Everything seems to be good. They're very nice. Or maybe you're talking to a paralegal and you're like, I don't need to answer this because we're going to get this settled. And then as soon as the deadline's up, boom, they get a default judgment against you. And they tell the court, well, you took no steps to defend yourself. And so let's avoid that mistake. The second mistake is not getting the details of the agreement in writing. When I say details, I mean every detail. Whatever it is that you need to be able to settle the case has to be hammered out. You don't want it to be vague or, I don't know, he kind of said this or she kind of said that. No, you want it very, very specific. Third one is whatever those terms are, whatever the details of the settlement are, make sure you follow those exactly, like no deviation from them. And we'll talk about that. And then the fourth is, and for a lot of people, this is the end of it. Well, a lot of people sort of end with number 3. They say, hey, I did everything I'm supposed to. Well, number 4, you really need to make sure if one of the terms of the settlement is going to be that the case is dismissed with prejudice, well, you need to make sure that happens. Whatever the agreement is about the lawsuit, you got to make sure it happens. I would not rely on the collection lawyer to make sure it happens. And then fifth, and very, very few people do this, but it's super important, and that is check your credit reporting. You can do it while you're in the middle of a settlement if you're making monthly payments, but really after the settlement's done, that's where we see just, I won't say it's 100% errors, but it's like 90% of the time there are errors. And so I would definitely be checking that out. So let's talk about defaulting on the lawsuit. And, if you're wondering where I got these fancy graphics, it would be my fantastic art skills that unfortunately I peaked at like age 6 on my artistic ability. But here we have a suit that's served, so handed to you. Now you have a time limit to respond. If you don't, you're in default, and then they can garnish you, put a lien on your house, sell your house, whatever your state allows. And different states have different rules. Some allow wage garnishments, bank garnishments, seizing of property, real or personal. Some allow all of that. So you have to know what your state allows. So we definitely don't want to default on these lawsuits. So we start off and let me back up a second. So in my law firm, what we do, if somebody hires us and they have not been served, we file the answer anyway. We don't wait for them to be served because there's always a chance there's confusion where they serve, where they not serve. But from a technical standpoint, the clock doesn't start running until you've been served. Then the clock starts running. Now, in Alabama, where I practice, if you're sued in small claims or what's called district court, those are very similar, it's 14 days to answer. In circuit court, which is our higher court, that is 30 days. And what I would caution everybody on is don't make assumptions. Like I've had people argue with me. It's kind of funny in comments on YouTube videos. They'll say, this guy doesn't know what he's talking about. You always have 28 days to answer. I'm thinking, I've been a lawyer since 1995 in Alabama. I think I know what the rules are for the deadline to answer. And what it is somebody's looking at that saying, well, I believe that in this other state, it may be 28 days. Well, it may be, but you have to know in your state what the rules are. Let's see. I've got a comment here from Laura. Can't hear. Can everybody else respond and let me know if you can hear? Hopefully I've not been talking to myself here and you guys trying to read lips, or else use my very fancy graphics here. Let's see. Looks like, yeah. So, Laura, it might be that you might just want to refresh the screen, or maybe log out, log back in. I don't know. Sometimes it's like, when all else fails, turn the computer off, turn it back on type of thing. So, okay, well, we'll get back into this. And so we need to know what our deadline is. If we've been served, and we have to know our deadline, and then have we responded? And let me give you a scenario. This is from probably 2007 was, I think the first time I saw this happen was who person ultimately became my client, but they weren't my client when this was happening. They were sued, handed the lawsuit, okay? And in a moment, I'll try to go back and talk about what does it mean to be served, okay? But anyway, they were served, so the clock is running. In this particular case, they had 14 days. They're negotiating back and forth, and on like day 16, the collection lawyer filed a default judgment or a request for default judgment. It's sort of a procedure, two-step procedure in Alabama. You ask for it, and then it's entered. And what they put in an affidavit was, hey, we served this person, and she has taken no steps to defend herself. Now, they kind of left out the fact that, oh, we've had all these emails and phone calls and we're negotiating. They left all that out. So ultimately, we sued, the bad guys here, and they paid way more money than they were suing my client for. But the point is, don't put yourself in that position. Don't be vulnerable, because technically you have to answer. Now, we were able to sue because this collector ended up not being truthful in their affidavit, okay? But again, don't put yourself in that position. Don't give them the ability to run over you like this. So even if you're talking, whether you do this on your own, whether you hire a lawyer, either you or your lawyer needs to file the answer, the response, whatever it is. And sometimes people say, well, I don't want to file an answer. I want to file a motion to dismiss. Hey, file whatever you want to file. If you represent yourself, then obviously you make that decision. But the point is, do something to stop that clock from ticking, okay? You've been served, boom, clock's ticking, and the court wants to know, did you file a motion to dismiss? Did you file an answer? Did you file a request for extension of time? Like, did you do something? Because if you do nothing and the collection lawyer files that default judgment, judge may grant it. It may say, yeah, I know you were talking to him, but you defied my order, which my order was you've got 14 days or 28 days or 30 days or whatever it is in your state. So be very, very careful about that. Just a word about being served. Sometimes people think, well, the only thing that means is that the paper's handed to you personally. And that certainly is service in Alabama and every place I know of. But that's not the only way to be served. You can get a certified mail. Some states allow that. You sign for the certified mail, you've been served. Other states allow, including Alabama, for the papers to be delivered to somebody who lives in your house. They don't have to give them to you. So it doesn't have to be your spouse or an adult child. It could be a roommate. Roommate gets the paper, they look at it, throw it away, never tell you. Guess what? The clock's running. So that's why I always caution people who say, well, I'm pretty sure I haven't been served, so I'm going to do nothing. We got to be real sure, okay? Because you might not personally know about it, but yet the clock is ticking. So you can contact the court, or obviously if you're working with a lawyer, get with your lawyer. But this is why as soon as we know about a lawsuit in my firm, we file an answer, because we're trying to run towards trial. We are not trying to delay things, okay? And I won't go through the whole story, but yeah, I've mentioned this before about, remember the story from the Bible, David and Goliath. And Goliath there, he's this giant, he's got all these weapons of war. And David he's not like 12 years old, but he's probably like 17 or 18. And he's got, a staff with a slingshot on. Well, it says he ran towards Goliath. You got to think Goliath's going, this is weird. Why is he running? You got to be running away from me. Well, that's kind of what we do. We say, we don't want to wait till we're served. We want to attack. We want to go forward and get to trial as soon as possible. So I'll check the chat here to see if we've got anything. Let's see. Laura asked, let's see, is it being recorded? Yes, it'll be recorded, and you should get, everybody, whether you're live or not on this, you'll get an email with a link to the recording, and I'll probably put this up on YouTube as well. So if for some reason you don't get it or you can't find it, just let me know. Let's see. Shauna says, can they mail it to you? Because I've heard if you don't pick up that mail, it gets returned, so you're not served. So that's going to depend on your state, and sometimes depend on the judge. If the post office says, like, you refuse to claim it, well, then the court may say, well, you've been served when you refuse to claim it. The other thing is, if you're not served personally, or somebody in your house, or certified mail, they can do something called service by publication, which is they find, if you still have a newspaper in your county, and it's not always the case anymore, but they kind of take whatever the nearest county is, and they put a legal notice in there. Well, nobody reads that. Well, as soon as it's run, boom, you're served. So I may have mentioned this in a video one time, but I had a lawyer one time call me. It's like, all right, 11 o'clock at night. I look down, like, it's a lawyer that refers me cases, and, answer the phone, and I'm like, hey, what's going on? It's like, John, can you hear me? I'm like, yeah, what's going on? I'm in the closet hiding from the sheriff. They're knocking on my door, and I'm like, go answer, go get the summons. Like, let's deal with it. Let's not try to dodge it. Okay. So anyway, the point is, if you've been served, whether you know it or not, you got to get that response filed in time, or there'll be a default judgment. Let's see. Colt says, what they mailed to the wrong address, but an address you own. They serve it to your tenants in your rental, not your mailing address for notice. So you have to look at each state, and for example, Alabama, the rule is if they serve somebody who lives in your residence, okay, or your abode. So that would not be your rental house that you're renting to tenants, but it's where you actually live. They can hand it to, I'll just sort of shortcut this, not exactly true, but basically an adult, okay? I mean, we can get into arguments, is this a 16-year-old or whatever? But let's just say adult in your residence. Now, not somebody just visiting, not your cousin for the weekend, but somebody that actually lives there. That could be a roommate, could be a spouse, could be an adult child, and they might never tell you. I certainly have had clients come to me and say, hey, I got this default judgment, and we sort of trace it down, and we realize, oh, they served, your mother who you live with. And then we talked to a mother, and she's like, yeah, I didn't want to upset my daughter, so I threw it away. Like, well, now we got a default judgment we got to try to undo, which is possible, but it's difficult a lot of times, and it's unnecessary to do that. Okay, so let's look at the next mistake here. That is not getting details, okay? So what happens is somebody's on the phone with the collection lawyer or the paralegal or collection person at the firm, and they say, okay, I'm going to pay $1,200. And okay, that sounds good. Thank you. All right, we'll work on that. Well, who are you going to pay? You paying the collection law firm? Well, presumably you are. All right, you're paying $1,200 all at once or over time? Well, the consumer may say, well, I assume they knew I'd pay over time. Well, the collection lawyer may say, no, I thought $1,200 all at once. Well, when are you going to pay it? Collection lawyer may say, I thought you were bringing it tomorrow. That was our deal. And you say, well, no, I thought it was at the beginning of the year. Well, how are you going to pay it? Going to pay it by wire transfer, by personal check, cashier's check, certified check? How are you going to pay it? Okay. And the reason this is important is they may say you must pay with a cashier's check, certified check, money order, and you pay them on the deadline with the personal check. They may go, nope, you broke your agreement. And now the whole amount's due. Okay, so you want to know all these details, like whatever the details are, like so that you could explain to somebody else, here's how we uphold our end of the settlement agreement. Well, we got to know who to pay, who to make the check out to, or if we're doing wire transfer, what are the wire accounts? We've got to know when we're paying it, how often we're paying it. What do we need to put on the check? Do we need to put like a case number, a file number? What do we need to do? Sometimes the name we're sued in and the name that we're using is different. So, maybe your name is Cindy Smith, but you're sued under your maiden name of Cindy Jones. And so you just send a check that says Cindy Smith and don't put any information. They're like, well, we're trying to figure out who does this belong to. So we just want to get all those details, including the detail of what happens after I make this payment. So let me give you a couple possibilities. One is they say you have to agree to a consent judgment. It's just what it sounds like. You consent, you agree to a judgment. And what they do is they say, as long as you make your payments, we will not garnish you or execute on the judgment. Okay. Well, if you agree to that, I'm not a huge fan of that, but if you agree to that, what happens after you're done? Now, there is no dismissal with prejudice because the case is over when that judgment happens. Are they going to file what's called a satisfaction of judgment? Maybe called something different in your state, but the idea is that it tells the court and the world who's looking at that court case in court that it's been satisfied. It's been paid. There's nothing more owed on it. Are they going to do that? Are they going to put a lien on your real property? Sometimes that's done in probate court. Again, it depends on the state. Well, if they do that, will they file a release of lien? I mean, we need to know these details before we agree to it. Well, let's say we're not doing a consent judgment. We're doing, we're sued for $5,000. We're paying $3,500 in a lump sum. Well, what happens after we pay it? Is case dismissed without prejudice or with prejudice? Big difference. Without prejudice, it's like they never sued us. With prejudice generally means, certainly in Alabama, it means is that you do not owe any debt. Okay. So what are they going to do? Like, we need to know these things. What about, if let's say I have a trial date next week, but I'm supposed to pay 30 days after that. What happens? Do we do the trial? Mr. Collection Lawyer, Miss Collection Lawyer, are you going to move the trial? Are you going to let the court know that we're settled and to continue the case? How do you know if they've done that? Are they going to give you a copy of it? How will you know the court grants that? So I'm not trying to say this is too complicated. What I'm saying is you have to put some thought into it and say, okay, hey, here's my trial date, but I'm paying up, 30 days after that. That seems like a problem. What's the solution? There is a solution. You just need to know from the collection lawyer, what is the solution? And then you want to make sure that they follow through on that. Let me see here what else we've got. I'd say I missed a part here from Shauna about if you don't pick up the mail, you're not served in Alabama. I have seen judges go both ways on that. It kind of the explanation is if it looks like you're dodging service, in other words, you're trying to avoid service, the process server who's knocking on the door, whether it's a sheriff's deputy or a private person, they tell the court that, I'm pretty sure Shauna was home, but she's not answering the door. Or, I approached her and she lied and said it wasn't really her, but I know it is. And then she didn't pick up the certified mail. Well, now the judge may be ticked and say, you know what, I'm going to say that you were served and enter judgment against you. So just be very careful about that. I just personally would not, dodge or avoid any type of certified mail. Let's see, Bruno, how can a collection company prove you received their letters and attempt to collect a debt before placing on a person's credit report? When you request proof of the letter, they can't provide proof, didn't send it certified. So, Bruno, I'm going to come back to that. If for some reason I don't, just remind me at the end, but we'll talk about that because that's under Regulation F of the FTCPA about what has to happen before they credit report. And it's a great question. We'll come back to that. Okay, so let's go now to kind of get our place here, defaulting, and then the details. Okay, we've got to have the details. Well, now we got to follow the details, right? So when am I supposed to pay? Well, don't pay late, pay on time. Well, am I paying the right amount? Pay the right amount. I saw somebody, this is in a slightly different context, but they were going to lose their house unless they paid like $5,000 by, let's say, the 20th. And so they wrote a check for $5,000 and they mailed it, and it didn't get there. They assumed it would get there. They actually sent it certified, but they didn't check on it. And it turned out, instead of going to like Wells Fargo in Minnesota or wherever they are, it goes to like Alaska. And then 3 months later, it gets delivered. They didn't pay. And they go, but I tried to pay, but you didn't pay. So if the deal is you pay $500 a month and you pay $499, you didn't pay $500. So you want to make sure the timing, the money, the form, is it cashier's? Is it money order, certified check? What is it? And the bottom line is you got to prove that you sent it and it was received. Now, that might be you walk into the collection lawyer's office and you hand them money and you get a receipt back. That's pretty good, right? Now, I'd still download Adobe Scan. If you've been through any of our webinars, we talk about this. Adobe Scan on your phone, the best free scanning app that I've seen, actually better than the paid apps. Scan your check, whatever you got, okay? But then get that proof that it was received, or send it certified, or send it, priority or overnight, whatever you've got to do so that you're not leaving yourself vulnerable. It's sort of like, when you're learning to drive, or you're teaching your kid how to drive, and let's say there's two, 18-wheelers, and you pull up right in both of their blind spots. That's not a good place to be. Now, they're not supposed to, merge over onto you, but why put yourself in that position where it's hard for the truck driver to see you? Why do that? Let's slow down, or let's speed up, right? Let's not be in a position where we're going to make it difficult for the guy or gal that's driving this huge truck to avoid a wreck. Let's make it easy on them to avoid the wreck. So same thing here. We want to protect ourselves, kind of like defensive driving. We want to protect ourselves and show that whatever the terms of the agreement were, we followed them exactly, and we can prove that we followed them. Okay, so here's step 4. So don't default, answer instead. Get the details, follow the details. Now, number 4, let's make sure that we get the case dismissed with prejudice, or whatever the agreement is. If you did a consent judgment, that they satisfy the judgment. Whatever it is, just make sure it's done. A lot of times this step is forgotten. And it turns out that, we think the case was dismissed, it's really not, or we think the judgment was satisfied and it's not. And then we're buying a house, refinancing our house, and the day before, we get this frantic phone call about there's still a judgment out there against you. You're like, no, I paid that off. Well, you got to make sure it happens, or you may be scrambling around at the last minute. So whatever the deal is, make sure that happens, and figure out how you're going to determine how that will happen. Is the collection lawyer promising to send that to you? Do you have online access to your county court? Can you watch your case, see everything that's filed, every order that's entered? Can you call your court and ask them, hey, this is John Watts, Capital One sued me. Here's the case number. Has there been a satisfaction of judgment? Has there been a dismissal with prejudice filed? Has the court entered an order? And, you've got to figure out, maybe you got to go there in person, but you need to know, how will I know that this has been handled per our agreement? See, if you follow all the terms of your agreement, you pay the right amount, the right time, the right form, you pay the right person, it's made payable to the right person, then you can expect them to follow up on their end of the bargain, right? They've got to satisfy the consent judgment, dismiss with prejudice, my preferred method of the lawsuit. So whatever it is, you want to make sure that they've done that. And then here's kind of the bonus thing that, if 10% of people do step 4, like 0.5% do this step, and that is check your credit reports. And what we want to make sure is that our credit reports are accurate. Now, the point of this is not to go through a whole class on credit reporting, but here's the basic steps. So we get our reports. All these you can get online. So you go to annualcreditreport.com. That'll get you Equifax, Experian, TransUnion. Go to clarity.com, which is owned by Experian. Get that. Some original creditors will be on there. Now it's more of like Speedy Cash and things like that, but it'll have like OneMain or Rise, some that we see will actually sue. And so you pull your Clarity report, pull your Innovis report, Innovus, I think. And that will not have any debt collectors. Clarity will not have any debt collectors, but Innovis will have your Synchronies, your Capital One, Wells Fargo, Discover, Citibank, those types of companies will be on, even OneMain. So OneMain could be on Equifax, Experian, TransUnion, Clarity, and Innovis. And so you want to pull those reports, and then you want to analyze them. And we'll come back to that in a second. But after you analyze them, then you dispute. And I put on here show and tell. And the idea is let's tell the bureaus what's wrong. Tell them in words. You type it up. Don't be sparing with your language. Like, some people are like, well, I'm trying to fit it all in. So my whole letter is 1 page. Why? If it's 2 pages or 12 pages, who cares? Make it as long as it needs to be. Explain what's wrong and then show them. So take those pages of your credit report. I like to include the front page has your name and Equifax, a confirmation or report number. And then all the pages that relate to that particular account. Circle the stuff that's wrong. Draw arrows, like it'll say TransUnion, date of last payment, and it will have literally the date you last made your payment, the settlement payment. It'll have amount paid 0. That can't be true, right? If I paid 0, I didn't pay. If I paid, it's more than 0. You circle that, draw a line, circle the 0 payment. Whatever it is that's wrong, circle it, highlight it, draw attention to it, so that if this ever goes in front of a judge, you can say through your lawyer, hey, we did, show and tell, right? We showed them what was wrong and we told them what was wrong. So if they go, well, we couldn't understand all your scribblings on our credit report page, that's okay, because I typed it up for you. Or if they go, well, we can't read more than 10 words. We're the credit bureaus. We're incompetent. That's okay. You should have looked at the images, the pages of the credit report where I drew circles and lines. And then you want to get those results back from the credit bureaus. And again, I'm not going through the whole credit report thing, but send it certified mail so you have proof. Get the results back. They fixed it. They deleted it. They did everything they're supposed to. Or they are not deleting it, not fixing it, not making it accurate and complete. Well, then you can dispute again or you can sue. And there's different strategies there. So let's talk about in terms of, what are some typical errors? Well, you want to look at that report and see, are there any obvious missing pieces of information? So in the payment history, are there just months that are missing? Well, that would seem to get your attention. You want to circle those and point those out. Are they not showing the payment? So Experian is kind of legendary for, they'll show a month and there's typically kind of goes up if you get it off annualcreditreport.com, which is where I recommend. So you see like $5,000 balance next month, $4,900, next month, $48, $47, $46. Like obviously you're making payments, and then over to the right, they have 0 paid. Well, that can't be right, right? If I didn't pay anything, the balance wouldn't go down. If the balance is going down, I paid something. So you just look for these things. Are they showing, for example, a charge off in a month after you paid? Now, I'm not talking about, are they historically saying, well, 2 years ago, charge off. I'm saying like, I'll use myself as an example. Let's say I have a Discover card and it's charged off and I start paying in January and I finish in June. So I'm done in June. They dismiss the case with prejudice in June. I owe 0 in June. Well, do they report me as a charge-off in the month of July? Do they report a 0 balance and a charge-off? Kind of weird. How can I have a 0 balance and a charge-off? 0 past due and a charge-off. Do they, let's take my example I used before. I was sued for $5,000. I paid $3,500. Do they do the math there and say in July, remember I paid it in June, in July, do they say balance is $1,500? It's not $1,500. It's 0. I don't owe them anything. I paid everything I owed them. We made a deal. Remember, that goes back to step number 2 or mistake number 2. Got to get all those details in writing. So we made a deal. I pay you $3,500. You dismiss the case with prejudice. I do it by, June 15th, whatever. Well, then how can I be late in July? How can I be late in August? How can it be a charge off in August? So you just look at the report, really analyze it, and then put all that in the letter. And again, attach the pages of the credit reports. And that will go a long ways toward getting it fixed or deleted. Or if they won't do either one, then you may be in a position where you can sue. Now, some people like to do multiple disputes. Some people like to just do one dispute and then sue. Different strategies, advantages, disadvantages. And that's not really the point of this webinar. But I wanted to give you this to say, sort of see these 5 mistakes, right? We default. That's a huge mistake. Kind of hard to settle when you default. And then we get the details, and then we follow those details, and then we make sure whatever the agreement was after we're done paying, that they do what they're supposed to do with that court case. And then the final thing is what's on the screen now, which is to make sure that our credit reporting is accurate. And if it's not, let's dispute that very clearly, accurately, completely, because we're demanding that they be accurate and complete. So let's make sure that we're like telling them everything that's wrong. Give them a chance to do the right thing. When they don't, then you're usually in pretty good shape for a lawsuit there. Okay, so that's really all I had in terms of the slides there. So let me go back on the questions here. Let's see. Let me pick up Bruno's question. And again, if you guys have questions about what we talked about, settling original creditor lawsuit, or if you have just other consumer questions, I've got a little bit of time here before I have to get back to battling the credit bureaus in federal court. So Bruno says, how can a collection agency prove you received their letters and attempt to collect the debt before placing on the credit report? So what Bruno is referencing here is accurate, that a collection agency has to notify you, by phone or in writing to let you know before they credit report on you. And that was not exactly the law, or at least wasn't recognized as the law before Regulation F, which went into effect November of last year. But certainly now it's understood they have to do that. Well, what if they don't send it by certified mail? How can they prove they did that? The answer is what we call the mailbox rule. So a lot of misunderstanding about what this means. I'm trying to see if I have an envelope around here. So here is a good Blue Cross Blue Shield of Alabama envelope here. I don't know if that's legible or if that's coming up backwards or not. But anyway, so let's say debt collector puts it on my credit report. I go, wait a minute, you didn't tell me. And then they go, oh, yeah, we sent it to you. And I go, I didn't get it. They go, well, whether you got it or not, we sent it to you. So the mailbox rule says if they can testify that they properly addressed, put proper stamp on it, it wasn't returned, then there is a presumption that it was delivered to me. Now, at least in Alabama, I think in most states, but at least in Alabama, the law is very clear that if I say I did not get that, and particularly if I sort of go above and beyond that and talk about here's my system for handling mail, I always grab the mail, always put it to the left of my phone on the kitchen table, because I still have a phone like mounted on the wall, put it there. And then I go through it every Thursday night, whatever my process is. And I didn't get the letter from the collector. Now that raises a question about, did they actually mail it? And now they could have solved this. And Bruno points this out in this question about, you ask them and they're like, well, I don't have any proof because we didn't send it certified. That should be, not all judges follow this, but that should be what we call a fact issue. In other words, a jury's going to have to decide, did they mail the letter? Did they not? If they mailed the letter, they're okay. If they didn't mail the letter, they violated the law. And so that's just something a jury's going to have to decide. So I think it's dangerous for collection agencies to do this. It's the same reason why when we send stuff out, almost always we send it by certified mail, because of course the credit bureaus are going to say, we didn't get your letter. Well, but you signed the card for it. Of course the collectors are going to say, oh, we never got your dispute letter. That's why we didn't mark your account as disputed. So you can't sue us. You got to drop your lawsuit. We go, well, we sent it certified and you signed for it. And so if you don't send stuff by certified, you leave open for the person who supposedly received it to say, I didn't get it. And when they honestly say that, I mean, now a jury's got to ultimately decide, well, was it mailed or was it not mailed? And I don't want to be put in that position if I'm trying to send something to somebody. Now, if they sort of do it the cheap way and they won't do it certified mail, and my client says, hey, I didn't get it, that's a problem of the mortgage company, the debt collector, whoever supposedly sent that letter. And there's a case out of let's say it's a 10th Circuit Court of Appeals where the judge that wrote the opinion is just kind of blasting this company for like, good grief, why didn't you send it by certified mail? We're having this whole federal litigation because you were too lazy and cheap to spend $6 by certified mail. If it's really important, send it certified mail. Now, that's not the law, but that just sort of, I think that judge sort of spoke out loud what a lot of people think, which is like, come on, if it's really important, send it certified mail. So Bruno, I hope that helps. They can't prove it other than to say that they mailed it. If you say you didn't get it, and you can honestly say that and describe in detail about that, then I think most judges, at least in Alabama, would say, you know what, we got to have a jury decide that. Let's see. John wrote, would it be a violation if their attorney mailed you letters even though they know you already have an attorney and all mailings or correspondence should go through my attorney? So the short answer is yes, if we're talking about a debt collector. Now, if it's an original creditor, sending communication to you, that may or may not violate the law. It really depends on if you have a state law. Like there is no state law in Alabama that sort of takes the FTCPA, Fair Debt Collection Practices Act, and applies it to original creditors. But in Florida, there is at least some parts of the law. California, there's the Rosenthal Act. Texas has some finance code or something that I think applies to original creditors. So if a debt collector, which could be a collection lawyer or a collection agency or a debt buyer like Portfolio, Midland, LVNV, if they're writing to you and they know you have an attorney, then yeah, that violates the FTCPA. Let's see, can that opposing attorney be sued or sanctioned? They not only know I had one and also admitted they knew I had an attorney. Okay. Oh, I got it. They not only knew I had an attorney, also admitted they knew I had an attorney. So sanctions, maybe, okay, but this is going to get a little more detailed. If we're in litigation and they know you have an attorney, yes, they have to communicate with your attorney, at least if your attorney has entered what's called a notice of appearance in the case. But sort of besides, so that's like the state law, okay? If they violate that, yeah, they might be sanctioned for an ethics situation, communicating with a represented client, represented person. But it's more commonly that they would be sued under the FTCPA. So you have to make sure that debt collector qualifies, or that collection lawyer qualifies as a debt collector, and then you would look at suing for that. And let me just see if I can pop this up real quick here. And we will look at the law here, 1692C. And so this is going to be dealing with communication. Make sure that's big enough so you can see it there. So with let me just go back kind of so we can get our bearings here. So this is the FTCPA. These are all the sections of the FTCPA. So we want to look at section C, which is communication. And then, so we've got A, which is just saying without prior consent, then they cannot communicate. Here's the first one, unusual time or place. Look at this one. If the debt collector knows the consumer is represented by an attorney with respect to such debt, has knowledge of, or can readily ascertain such attorney's name and address, blah, 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 then that would be a violation of the FTCPA. So hope that is helpful to you. All right. So let me go back to, okay, Ryan, I have a client who has a credit report with same experience mistake you mentioned. The balance was going down, but the amount they said he paid each month was zero. Furnishers Capital One, we disputed the zero entries. In other words, the zero payments there. And noted in the dispute the payments were not zero because balance is going down. Pretty smart. I mean, the mistake was not fixed. Does it make sense to bring a claim under 1681 S2B against Capital One, or just an EB or I claim? So let's, okay, they says truth is he actually made payments for the months. They said he paid zero, so the entries were inaccurate. Yeah, and look, this sort of two sides of the same coin. They're inaccurate and incomplete. I mean, it's inaccurate to say he paid zero. It's also incomplete because they didn't put the actual amount. So let's look at the law. So I know Ryan knows this, but just to make sure we're all on the same page when we're talking about these sections. So 1681E, this is going to apply. Actually, let me back up to the FCRA. So we've got, definitions, permissible purpose. That's for pulling credit reports. Just some requirements here. We got identity theft. And then we get to E, which sort of doesn't really sound that exciting, compliance procedures, but it's actually really important with a credit bureau. So let's look at this. And this is what Ryan is referring to. This part right here, accuracy of report. Whenever a consumer reporting agency like Experian prepares a consumer report, so this is not just you pull your report and see this. It has to be prepared and then delivered to some type of user. Could be for an account review, a hard inquiry, soft inquiry, whatever it may be, okay? Then that credit bureau shall follow reasonable procedures to assure maximum possible accuracy of the information concerning the individual about whom the report relates. So let's take Ryan's situation. We got the balance, starts up here and it's going down. But then they say zero is the payment. Well, it doesn't take a genius computer engineer, it seems to me, to figure out that you put into the program, hey, if you see the balance going down and you see the amount paid being zero, that ought to raise red flags or set off an alarm, right? Like something's not right here. So when I have sued under this, I have sued under EB, assuming we had a report prepared, which, you almost always do. And then the next section that he mentioned was I. So let's look at I. This is for investigation. It's actually called a reinvestigation because supposedly there was an investigation made when the data was first put up. You can kind of think back to that EB claim. But anyway, so it's called reinvestigation, but just remember I is for investigation. And so when you see something that's incomplete or inaccurate, and it doesn't have to be prepared for somebody, so you could just pull your own report, you see what's wrong, you dispute it, that section I is triggered. Then they have to investigate it. And if they can't determine it's accurate or complete, they've got to delete it. Okay. So we almost always, if we've done a dispute, we'll sue under EB for maximum possible accuracy and for I, doing a lousy investigation. The other law he mentioned was S2B. So if we come down here, responsibilities of furnishers. So we have this section A, which sounds great, but we can't sue on it. So we have to go all the way down to B, and it sort of goes a long way here. We'll see here if we can find the B. Whoops. Okay. I did something, made my screen way too big there. All right. So let's see here. All right, here we go. I knew it was a long ways down, just maybe because my text was too big there. But this is saying when you do a dispute under section 1681I to a credit bureau, and then they notify the furnisher has to conduct an investigation. They have to review all the relevant information, report back to the credit bureau, and if they find the information is incomplete or inaccurate, they have to delete it here. Inaccurate, incomplete, can't be verified, then it has to be deleted. So to answer the question that Ryan posed, what I would do in that situation is I would sue both of them. I'd sue Experian for EB, assuming there was a publication, and then I'd sue Capital One for S2B for doing a lousy investigation. Let's see. Colt says, when reviewing credit reports, need additional information such as knowing what the furnisher provided inaccurate adverse information. Is there an equivalent to request for information like in RESPA? So it's a very good question. RESPA deals with mortgages. And so these used to be called QWR, Qualified Written Request. We kind of changed the name about January of 2014 to a request for information and a notice of error. And those are exactly what they sound like. I request information from my mortgage company, or I'm putting my mortgage company on notice that they made an error. I want them to investigate and fix it. So there's not really the same thing to the credit bureau, except for this. You're entitled to have your full file disclosure, which would mean everything that the furnishers, including other information that the credit bureau has on you. So if you say, hey, I'm concerned about what this one furnisher has reported, I don't think it's correct, you could go to the furnisher and ask. They don't really have to tell you, at least for you to have the ability to sue. They don't have to tell you. They're supposed to tell you. But you could ask them, but you could also ask the credit bureau for your full file disclosure. And let me show that to you. So this is what is often called the Section 609 letter. Now, most people, when they're talking about that, it's crazy the things that people come up with. They think a 609 letter is like this magic bullet that makes everything go away. And anything can work, anything can get something deleted, but you can't sue on it. But what a Section 609 letter, which is also Section 1681G, there's always like two forms of numbering just to make it confusing. So this is information on file. Every consumer reporting agency shall, upon request, clearly and accurately disclose to the consumer all information in the file, except, and then there are certain exceptions not really relevant to us. So you certainly could ask the credit bureaus. I think it's a good idea. Give me my full file disclosure. Let me see everything that you have. And often between that and what the furnisher may give you, it may be enough for you to figure out the answer to your questions. And if you can't figure it out, and the credit bureaus won't give you the information, then we certainly sue under this section, Section 609, or as using sort of the more, not technical, but most courts use the 1681, and then it would be G, 1681G. All right, so Derby says, how does the consumer handle attempts to service a process if an active bankruptcy? Sheriff's Office is given notice of stay and bankruptcy protection. Does that protect the consumer regarding violations of bankruptcy? So, okay, let me see if I'm understanding this right. I think so I filed bankruptcy, and there's what's called an automatic stay. It kind of tells everybody, hey, stop collection, don't do anything. What if the sheriff's office knows that and they still serve me? Well, I wouldn't sue the sheriff's office over that. I wouldn't sue the creditor over that, assuming the creditor had notified the court where that lawsuit was filed that there was a bankruptcy. So there's something in most states, you file this document, it's called a suggestion of bankruptcy. If the client's died, you call it a suggestion of death. It's just an old sort of way of saying it. So as long as they've done that, then I think they'd be okay. Now, if we're sort of flipping it around and saying, hey, what if we've sued somebody and they filed bankruptcy? Are we guilty if they're served? Well, again, as soon as we know as a plaintiff that a company or a person we have sued has filed bankruptcy, we've got to notify the court that where we filed the lawsuit that, hey, this case is subject to bankruptcy now. So hopefully that answers your question. Let's see. Derek says, can you speak to the history fields on the annual credit reports? Payment history is the only history mandated by Metro 2. Have you had luck with other missing history data? So I'll say this, and I don't know that this is controversial, but in sort of the small little world of people who like really get into credit reporting, lawyers, credit repair people, maybe this is controversial. I really don't care about Metro 2. Metro 2 is sometimes let me back up and sort of give the context here. So you have the four major credit bureaus, so Equifax, Experian, TransUnion, and Innovis. They form this organization, CDIA, and now I think they've spun off ownership of it for sort of conflict purposes. And CDIA has created this, we'll just call it a common language that the credit bureaus and the furnishers use that will allow these 10,000 furnishers who all provide information every month to the four bureaus. What's the format of that language? In other words, the credit bureaus don't want to have 100 different ways. They want one way to receive the data. And so Metro 2 is that language. Now, there's a book called the guidelines. And so often when we say Metro 2, we say, well, that's what we're talking about, is really that book, that industry guideline that says, okay, well, here's what you have to report. Here's how you report it. That is not the law. Now, it's funny, politics makes strange bedfellows type of thing. If we're saying, hey, you violated Metro 2, the credit bureaus be like, that's not the law. It's not remotely law. Like, it's just suggestions. It has nothing to do with the law. But now when we sue them and they go, well, but we follow Metro 2. I mean, that's like divine law. And so everybody kind of flips positions on it. If Metro 2 will help me, I certainly don't mind using it, but I really don't care. If the fields are provided and it makes sense for them to be filled in, okay, then I'm going to dispute that. Now, here's what I mean. If I'm looking at Equifax, and so Equifax has a summary, and then it's got 3 years for like balance, amount past due, payment, schedule payment, actual payment, available credit, high balance. If it's an installment loan, I'm not going to dispute the fact that it's missing the credit limit, because you don't have a credit limit on an installment loan. But if it's a credit card, I would. Okay. And, if it's an installment loan, it's missing scheduled payment, I'm certainly going to do that. I'm going to do that even if it's a credit card, because it's still a scheduled payment. You're supposed to pay $16 or $187. And so I really don't care if it's in Metro 2 or not in Metro 2. The bureaus are giving me information and it's incomplete. If it's incomplete, I'm going to dispute that. And if they, as they sometimes do, sort of hide the information from me, but it's in my file, well, then they better give me my file. Okay. So they can't have it in my file, but hide that from me and then not give it to me in my consumer disclosure or my credit report or whatever you want to call it. So hopefully that answers your question. Got a few more minutes here. Let's see. And just so you guys know, at 4:00 Central, I'll be doing a YouTube live. Just go to my YouTube channel with Stephen Palmieri, or if you're a member of his group, you'll see it in the Facebook group. And that'll just all be sort of live Q&A. Robert says, have a question about using 1099-Cs to remove charge-offs. Obtained several 1099-Cs for accounts that have been in charge-off status more than 3 years. Longer than my state statute of limitations. Have been informed since the original creditors issued 1099-C, the charge-off considered discharge, and it's classified as income. Realize original creditor may still come after me. That's not my question. Understanding is, since this charge-off is considered income and the IRS say income should not be on credit reports, should be able to get CRAs remove these. Okay, so the whole income thing, I've never seen any basis for that. Okay. The basis for using 1099-C, and the courts are split on this. Okay. So understand, if I tell you the negative side, there's a positive case. If I tell you the positive case, there's certainly a negative case. But the argument is the 1099-C is filled out. If a certain box is checked saying that, we basically have abandoned any efforts to collect this. And so therefore, it would be misleading, inaccurate to report it as a balance on my credit report. Now, the courts that accept that go, yeah, that makes sense, right? I mean, you tell the government, yeah, we're not going to get this. Well, you can't tell the credit bureaus that it's still owed. The other side of it is the courts go, well, wait a minute, you still owe it. The fact that they don't think they can collect it, Capital One or Citibank or whoever, doesn't change the fact you still owe it. They certainly can still sue you for it. And now if they get money, they may have to report that money as income because they've already gotten the tax write-off on it. And and I think I did maybe like 4 videos on my YouTube channel a couple of years ago, kind of tracing, like, let's start with what 1099 looks like. Let's look at some decisions here to see kind of what the trend is. And so you might want to take a look at those. I think if you just go on my YouTube channel and search 1099C, you'll probably come up with that. So let's see. Colt says, tip I just learned. My wife signed up for informed delivery from USPS. They send email scam pages, every letter addressed. Therefore, you have another digital. Yeah, that's a good idea, Colt. Actually, I had that. I moved recently, and I don't know if that's automatic or maybe I just like clicked a button, signed up for it. It's not perfect. I mean, there's things that come that are not scanned in there, but it does help you to sort of make sure that you know what's supposed to be in your mailbox anyway. And if it's not there, you can figure it out. So let's see, Diana, car was repoed today, 40 days ago, disputed the debt with them. I'm assuming them is the car finance company. Cease and desist, notice a dispute with certified mail. They continue to call and try and collect. Said they don't see any inaccuracies on my credit report. Told them 2 weeks ago I get paid on Thursday, then they repoed my car anyway. Should I file suit now? It's the assignee that repoed the car. So here's what I would say to you. This goes back to something I mentioned earlier. You have to know for your state, is that company you were dealing with, are they considered a debt collector? Okay. And so they'd be covered by the FTCPA, or are they considered a creditor? And if they're a creditor, does your state law have the same rules about cease and desist and things like that? I will say this, if you send a cease and desist, that really prevents them from communicating with you unless you reach out to them. In other words, we can't do a cease and desist and then say, and I want you to send me information, because now we're putting them in this sort of unwinnable position. And so it does nothing to them. If they repo the car, so that's not a communication. So they don't have to, send you a letter or communicate with you. They just repo the car. Now, there's certain requirements after that. Hey, we have your car. Hey, we're going to sell it. Hey, we have sold your car. And they have to make sure and follow those. Typically, the law is if there's a requirement to communicate, if you've sent a cease and desist or cease communication or refuse to pay, then they're allowed to still do the communication where they're required to communicate with you. So what I would recommend is get with a lawyer in your state who does this type of work and see if they see any violations there, and see what you disputed on your credit report, what the results were. Is that, is everything good? Is there something there you can sue on? And then you'll know your options better. Let's see. Colt says, website says only serve clients who reside in Alabama. And I will say this, we need to update that. Excuse me. There's a lawyer that works with me, Blaine Dixon, very good lawyer in Tennessee. And so we do take clients in Tennessee. Blaine represents them in Tennessee. Are you available to be hired on as special counsel or consultant by my lawyer? Expertise, RESPA law, almost impossible to find our own state. I'll say this. I certainly have filed a lot of lawsuits under RESPA. It's not something that I really do now. But if you have a lawyer in your state that has a question about something, I always try to, chat with other lawyers. Occasionally we will co-counsel with lawyers in other states. We'll work with them. Basically we split the work, we split the fee. They get us licensed in another state. And, but I only do that if I think that would really help. And frankly, if I have time to do that. So they certainly can reach out to me and I'll be glad to chat with them. Let's see. Can you do a rescission after being repo? So that's a good question. Normally rescission, I think of at least in the mortgage context. And generally you have to pay back all the money that you borrowed and stuff like that. I don't know in this context with a repo if you can do that. I would definitely get with the lawyer in your state about it. Bruno, where is the best court to sue a credit reporting agency? State, county, or federal? So I'll give you kind of the arguments, and I'll tell you what we've done for many, many years. And I would say the way that we do it, used to nobody did it the way we did it. And then, well, I shouldn't say nobody, but very, very few people thought we were just sort of these bizarre weirdos for doing it. And now it's being discussed at consumer conferences. We're like, hey, we just discovered this new thing. So here are sort of the two options. The easy thing is you file in federal court. Okay. The problem with that is there's this issue called standing, which allows judges to say, hey, I don't think that you really have been harmed. And so we have no jurisdiction over your case, so we're throwing you out. So we used to file a lot in federal court, and we had a Fair Credit Reporting Act case, and we're at what's called the pretrial conference, where we're talking about jury charges and when exactly we're going to do the jury trial. And I'll spare you all the details, and I'll sort of, sanitize some of this. But lawyer on the other side said, we don't think they're standing. Well, what that meant is if the judge agreed, my case would be thrown out. And some states have what's called a savings provision that basically says if you get thrown out for lack of jurisdiction, you maybe have X number of days or months to refile in state court, and there's no statute of limitation. We don't have that in Alabama. And so I'm pretty upset and annoyed that this is being brought up at the last minute. And as we're walking out, I turned to my law partner. I said, we're never filing a case in federal court again. Now, we file everything in state court with the idea that it's going to be transferred or removed to federal court. If they leave it in state court, I'm thrilled. Okay. That's where we do car wreck cases and things like that. But they almost always remove it to federal court. And then if they raise this issue of standing, they have to prove it, because the question is, who knocks on the federal courthouse door? That's the person that has to prove standing. We don't have to prove it because we didn't want to be in federal court. And so it's kind of funny. We've had credit bureaus remove our cases, and then they have to go argue basically our position, saying, oh, yeah, the plaintiff was definitely injured and harmed, and don't throw the case out. And we're just sitting back going like, we don't care. Throw the case back to state court. We're totally fine in state court. Let these out-of-state lawyers come into Alabama state court. So my view is, and for many, many years we've done this, we file in state court. I'd still say the majority of people with FCRA, maybe the overwhelming majority, file in federal court. Few of us that file in state court. FTCPA, more consumer lawyers are recognizing they're just getting their cases thrown out in federal court because of the standing issue. And so they bring those in state court, they get removed, and then the judge thinks there's no standing. He sends it back to state court. So you're fine. So I always do state court. Let's see here. We'll just do two more questions, and then we'll wrap this up. And if you guys are available, I'll see you in, a couple hours here. Let's see. Robert says, I have several accounts on Experian, which I have challenged in 3 separate letters over the last 6 months. Even though I've disputed, Experian failed to post a notice of dispute on any of these accounts, despite follow-up letters. Is it time for me to file a CFPB complaint, ask for removal? So I would give you a couple suggestions. One, go to a lawyer in your state who does this type of work and ask them to look at this. Generally, the rule is on the notice of dispute under the FCRA. So we'll come back to the FTCPA, but under the FCRA, Fair Credit Reporting Act, when you dispute something, it has to be noted as being disputed. There's a requirement of, it's called different things, sometimes a bona fide dispute, a legitimate dispute, a colorable dispute. And all that means is not that you have to prove that you would win, but it's pretty good, where everybody goes, well, maybe you're right, maybe you're wrong, but that's a legitimate, dispute that you have. So the classic case, I think I have a 20, 30, 40-minute video on this called Saunders, Saunders versus BB&T out of the Fourth Circuit. And it's a case that a great consumer lawyer named Lynn Bennett brought many years ago. Guy goes in, gets a car loan, and says, I want to pay it. They go, oh, no, you got to wait for your coupon book. This is back when you get like literally a book and you like tear off the coupon, put it with your check. He didn't get it. Calls back. Hey, I don't have my coupon book. No, we're going to get it to you. Don't you worry about it. They wouldn't take his money. And then like, I don't know, 2 or 3 months later, they send him the coupon book and then they report him as late. Like, you didn't make your payments. He's like, I've been trying to. Well, see, he doesn't have to necessarily win that to show that it should have been marked as disputed. Okay. Now, under the FTCPA, Fair Debt Collection Practices Act, you don't have to give a reason. It doesn't have to be sort of good faith. It just, if the debt collector knows or should know the account's disputed, which they might know that not even from you, maybe a previous debt collector tells them or the creditor tells them, then they have to mark the account as disputed. That's under section E8, 1692 E8. So I would just get with the lawyer, have them look at that. They may say you can sue. Hey, if you can sue, then I'd sue. If you can't, then yeah, maybe try the CFPB because sometimes that gets their attention there. All right, DeMarcus, does experienced attorneys give you actual attorneys hard time as they do us pro se? Probably not as hard of a time, okay? But we certainly deal with arguments that we look at these and go, what are you doing? You know, we've been through this argument a decade ago. You know, we know the law. And but it's just sort of a process. You know, some lawyers, you deal with the same lawyers over and over. Some you get these sort of brand new lawyers. And, you know, I mean, it always sort of amuses me when a lawyer I've never dealt with calls me and, you know, we get on the phone. They say, look, I represent such and such credit bureau and you've sued under this law called the Fair Credit Reporting Act. And John, I know you're not familiar with that, but you cannot sue a credit bureau under that law. I'm going to need you to dismiss this case immediately. Of course, I just play along with it. I go, are you serious? Oh my goodness. You know, I can't believe I violated the law like that. Are you going to sanction me? Or well, now, John, you know, if you would just dismiss the case with prejudice, we'll just let this go. And I'm like, you know, I don't really know anything about this. I mean, maybe I know like a little bit about this. So humor me, tell me what section I violated. And so anyway, so they do that. It's like uncontrollable sometimes for them. They have to do that, have to be sort of condescending. Not the good ones. The good ones know, you know, when the other side knows the law. But yeah, there's a little bit of sort of hazing of everybody by some of the bureau lawyers. All right, so Murley, multiple violations, debt collector, would you get 1,000 each? Generally, no. It's 1,000 sort of per case per defendant. Okay. The way the statute of limitation works is it's 1 year from every violation, but most judges I know of say you can't stack those violations to get 1,000, then another 1,000, another 1,000, like we can, for example, with the TCPA or with RESPA. Talking about these requests for information, notice of error letters. I mean, I've had RESPA cases with 100 violations. I've had TCPA with like 500 illegal calls that we get to stack on top of each other. But FTCPA is generally not viewed as that way. And okay, so the last one will be Laura, notice of voluntary dismissal without prejudice. So, and it says on both sides. So this means we're dismissing the case and there's no prejudice to it, which here's a way to think about it. I use this example sometimes. If you watch like a Jason Bourne movie or I don't know, James Bond movie, they may talk about here's the target, terminate them with extreme what? Extreme prejudice. It just means to kill, to wipe out, to destroy. Well, without prejudice means there's no harm. So if Capital One sues me and then they dismiss it with prejudice, it's over. It's done. They can't sue me ever again. Like there's been a determination that I don't owe that debt. But if it's without prejudice, it's like they never sued me. Okay. So without prejudice to either side means they can refile the suit. Now they have to make sure they're within statute of limitations. Some states will let you dismiss without prejudice, and then it adds like 6 months or a year onto the statute of limitation. Alabama's not that way, but some states are. So you have to know the rules of the state to figure out, can you be sued again? Can you sue again? And does that apply to federal claims or only state claims? So you have to know that. So a dismissal without prejudice in a lot of ways is good. It means the lawsuit's at least temporarily over, but it's not, you don't have that finality. You haven't sort of put a stake in the heart of that debt collector that sued you. They can sue you again. They can still call you, write you. If it's dismissed with prejudice, you don't owe it anymore. At least this is how it is in Alabama. So if they call you, they write you, they credit report on you, then you've got a valid claim there. All right, so I will let you guys go, and I will get back to fighting the credit bureaus here. And if you are available, I'll see you in a little bit on our YouTube channel. Should be 4 o'clock Central Time, and I'll be there with Steve Palmieri. Okay, guys, have a good one. Thanks for being here. I'll see you next week.